Who gets my kids if I die without a will in Arizona or California? But if you're a parent and you don't know the answer, you're kind of letting the state and maybe your most opinionated relative make the decision for you. In this video, I'm going to walk through, in plain English, what actually happens to your kids if you die without a will, how courts pick a guardian, and what you can do so your kids don't get stuck in the middle of a family tug-of-war. First, quick translation. When lawyers say you died intestate, we just mean you died without a will. No written plan, no guardian named, no instructions. People think, well, my family will just work it out. From what I see as a probate attorney, that usually means confusion, hurt feelings, and sometimes an actual fight over your kids. So let's answer this clearly. If you die without a will in Arizona or California, you do not get to decide who raises your kids. A judge does. Let's imagine the scenario. You and your spouse are in an accident, your kids are safe, but both of you are gone. What happens next? In the short term, whoever is closest, maybe grandparents, maybe an aunt or uncle, steps in to help. Pretty quickly though, a court has to get involved because someone's going to need the legal authority to enroll the kids in school, make medical decisions, and access money to support them. This is where guardianship comes in. If you died without a will, the court has no written clue from you about who should be guardian. So the judge has to guess based on who shows up and what they say. Here's how a court usually decides who gets your kids if you die without a will. Family members can file to be appointed guardian. Sometimes only one person volunteers, other times 2, 3, or more people raise their hands. The judge then looks at things like the child's existing relationship with each person, who can provide a safe, stable home, whether they can keep the kids in the same school or community, and any red flags like criminal history, substance abuse, or serious conflict. The judge is trying to do the right thing, but remember, this is a stranger in a black robe making a decision with limited information about kids they've never met, often in a tense courtroom with everyone grieving. Meanwhile, your kids may be watching adults they love argue about where they should live. If you leave a will that clearly nominates a guardian, the judge usually follows your wishes unless there's a serious problem. But if you die without a will, your voice is missing from the conversation. Now let's talk about the second half of the question parents don't realize they're asking. It's not just who gets my kids, it's also who controls the money I leave for my kids. Here are a few common landmines. You name your minor children directly as beneficiaries on life insurance or retirement accounts. You die without a will or trust. Your child is now legally entitled to money, but they're 8 or 12 or 16. Minor children can't legally manage that money, so what happens? The court may set up a conservatorship. Someone has to be appointed to manage the funds. There's court oversight, paperwork, and then this is the big one. In many cases, your child gets the full control at 18. 18-year-olds are great at many things. Carefully managing a large inheritance while grieving their parents is usually not one of them. With a simple plan, you can choose who manages the money for your kids, decide how it can be used, like for education, health, and support, and choose when your kids get access, maybe in stages at 21, 25, and 30, rather than one big 18th birthday check. Section 5, how to stay in control as parents. Let's shift from scary to practical. Here's how parents in Arizona and California can take control instead of leaving it up to the default system. Step 1, name a guardian in a last will and testament. You and your co-parent sit down and say, if something happens to both of us, who do we trust to raise our kids? You put that in a legally valid will. You can also name backups in case your first choice can't serve. This does a few things. It tells the judge what you wanted, it gives the person you choose permission to step up, and it takes a lot of pressure off the rest of your family. Step 2, use a kid's trust instead of dumping money on them at 18. You can set up a trust for your children that appoints a trustee you trust to manage the money, allows the trustee to use funds for your kids' education, activities, medical needs, and general support. Distributes money in stages, maybe some at 25, more at 30, so they can grow into it. The key is it keeps the money under adult supervision until your kids are actually ready. Step 3, fix your beneficiary designations. Life insurance policies, retirement accounts, pay on death or transfer on death accounts need to line up with the trust plan, instead of naming your minor children directly and sending your family back into court. Step 4, Update as your kids grow. The guardian you choose when your kids are toddlers might be different from the guardian you pick when they're teenagers. Good news, you're allowed to change your mind. The solid estate plan is something you update as your family and your kids need change. If all of this feels overwhelming, that's normal. Most parents I work with start out feeling guilty that they should have done this already. You don't need a perfect $1 million family plan. You just need a real plan that names who gets your kids if you die without being there for them. Protects the money for your kids instead of dumping it on them or letting the wrong person control it. Think of it as writing your kids a love letter that the court can actually enforce. If you're a parent in Arizona or California and you want help with choosing a guardian for your kids, setting up a kid's trust, or making sure your beneficiary designations and documents all match up, my firm Rilus Law does this every day. If you're not ready to talk to a lawyer yet, start by answering this one question tonight. If we weren't here tomorrow, who do we want raising our kids? Write it down, then let's turn that into a real plan.